you. And we'll come now to our next witness, who is our last witness, Lauren Quilligan. Lauren, really good to have you. And
Thank you.
Welcome, Lauren. It's good to have you here from Queensland. And sitting here before you are Dr. Helen Pringle from the University of New South Wales, Associate Professor, Mary Kerr from the Northern Territory, a police officer from the Northern Territory. We should have Bashi Kumar, but she's not here because she has young children who have caught the dreaded lurgy at kindergarten or preschool with the natural consequences, and Kerry Heubel, who's in adult education and also in the end of the 70s was the first executive officer to the New South Wales Women's Advisory Council, so has experience in governmental action or in relation to women's rights. So perhaps if you'd like to introduce yourself, Lauren, and then also tell us how it was that you became interested in and concerned about this area that you provided your witness statement.
Yeah, absolutely. Well, thank you so much for having me, firstly. So my name's Lauren and I'm Gold Coast. I am a lived experience advocate. I do a lot of speaking with JMAT organisation, the Sisters-in-Law Project. I'm also a family court mother. I've been through the family court. I have my own story, which unfortunately I can't share because of Section 121, which is one of the points that I'd like to focus on today. Yeah.
Good. Thank you. Well, we'll go to questions then. We note that you speak about the judges and how their opinions and views are outdated, and this has come from your observation and your feedback from women who've gone through the court process?
Yep, absolutely. So I suppose, you know, having had my own experience and having had some quite horrendous things said to me by judges in the courtroom, and then having spoken to hundreds of other women having been through the family court process and sort of comparing war stories in that respect, that the types of comments that are being made are very derogatory towards women and mothers, as mothers, and really don't take into account, you know, when you're looking at the context of domestic and family violence, and having that perpetrated against you, and the way that in which the comments made, things to the effect of, well, you chose to have a baby with them, or you should have known that to begin with, you know, make your bed lie in it. They're just some of the ones that spring to mind. You know, in a system that's dealing so heavily with people's lives and children's lives, but, you know, all of the people involved, comments like that are very outdated and very unnecessary.
Good. Questions?
You mentioned in here, in your statement, you talk about legal aid and how it needs to be properly funded and obviously accessible to women in order to provide fair and proper legal representation.
Yep. Yeah. So I suppose in my own experience, referring back to my own experience of legal aid, I have never been able to access proper legal aid funding. Not, you know, I don't earn a lot of money. I sit very, you know, obviously in a bracket where they're very reluctant to fund. My legal aid has been that in my matter, I was given legal aid funding, but to work with consent orders. So I was forced to orders that were very unsafe and were very traumatising for both myself and my child. And again, having spoken to hundreds of other women, there's just no funding for it. You know, and very recently I had 102NA funding sprung on me at the very last minute at the 11th hour, and again it was only for representation of the child, not for any of the prep work, which put me on the back foot. Yeah. it makes it very, very difficult as a mother when you're so highly traumatised by the process and you're put into a position where you're sitting in a courtroom with the perpetrator of your abuse and you're having to self-represent because there's just no funding for any legal representation.
I've got one. You've written here about the National Contravention List. It's in relation to the second example you give in your paper, where the father of the child had committed a number of contraventions, withholding the child for a period of 6 months without grounds. The mother then filed a contravention which took almost 12 months to be heard, but the father cross-filed a contravention and was able to bypass the National Contravention List. Could you explain to us what the National Contravention List is?
So fairly recently, I believe it was October 2021, they changed the system in regards to filing a contravention. So if one of the parties is in contravention of the orders, you used to go through your local registry. They attempted to streamline that by creating a national contravention list. By way of example, a contravention I filed was heard by a judge in Adelaide. I'm on the Gold Coast. So there was a process put in place by the family court to try and alleviate the backlog of contravention hearings, basically. So the standard process would be to file your application. It would normally take somewhere in the vicinity of 6 weeks for a response to be received. The father in the second matter had his contravention approved for filing within about 2 days. You would never hear of a woman having that happen. The mother in that matter, it took her 12 months to get a hearing.
Right. You refer to the family court report writers. Now, what role do the family report writers play, and how is it that they can have any impact on whether the woman's believed or not?
So the standard process of family reports is for the report writer to spend somewhere in the vicinity of an hour, maybe 2 hours with each of the parties, and then children may or may not be interviewed. Again, referring to my matter, the family report writer was actually less qualified than myself. She had a degree, a basic undergrad degree in social work. She spent a vast amount of time talking about herself in our interview. She then went on to make recommendations that impacted the entire outcome of my. Again, speaking to multiple women about this, there seems to be the family report writers are employed by the courts, and there seems to be a general bias against women, particularly, and I've referred to when there's allegations of domestic violence and sexual abuse, child sexual abuse in family court matters. There appears to be a very clear pattern of bias by all of the employees of the court. You can't raise those allegations.
Right. And you said also that in your recommendations, family reports should be done away with. Why do you say that, number one? And if I can ask, who actually writes the family reports and what is the purpose of the family report? And then number three, why do you say they should be abolished?
I think the purpose of the family report is to establish the story of each of the parties. And again, as I mentioned earlier, it's an hour, maybe 2 hours of interviews with a particular person, which is, it's very, very tricky to be able to adequately state your case, I suppose, in that respect to a family report writer under those conditions. So the family report writer, who is generally either a social worker or a psychologist who are employed by the court, will write the family report based on those interviews. And they contain a lot of opinion, which is, it's a really tricky space, because I suppose if you don't present in a way that is to them, then you sort of become automatically on the back foot. that family report writer will then make recommendations, which in about 90% of cases will be adopted by the family court judge, and they will run with those recommendations. And it's so incredibly damaging to women that, based on an interview that lasts for an hour or so, these decisions are being made, you know, by this one person and their opinion of you based on that interview.
And the question about training, your recommendation is that all judges and court staff need robust training in coercive control, FDV, I think that's domestic violence, and and trauma, to properly understand the dynamics in the court setting. One of the things that strikes me, and you please tell me if I'm wrong, is that if somebody comes into the court process who has been subjected to violence or coercive control, which of course is violence too, then they won't be able to be calm and measured in their approach. Whereas the other person, who is the perpetrator, has already been in the position of power and authority, so comes into the court without trauma, without having had violence inflicted on them or coercive control. So already you've got an imbalance in terms of the parties coming before the court. And come back to the family report, if the family report's written up by somebody who doesn't recognise that, then that would be a problem. If the person making the decision, whether it's a registrar or judge, doesn't comprehend that, then you've got a double, I suppose, the imbalance is increased, because you've got this person who's calm and cool, collected, you've got this person who's traumatised, then you've got somebody here who doesn't recognise that imbalance, and so they're simply compounding the imbalance here. Would that be the case?
Absolutely. And I know for me personally, and for many, many other women that I've spoken to, that, you know, we all have a degree of post-traumatic stress from our experiences as victims of domestic violence, and then being re-traumatised again by the family court process. You then put us in a position of high stress. It would be high stress to anybody to be sitting in a really confrontation, an adversarial setting like a courtroom at trial, when you're being hammered by a barrister, and then you throw in the PTSD and the fact that you've got your perpetrator sitting there eyeballing you while you're giving evidence. It's a very, very confronting situation to be in. It's very, very stressful. It's very triggering and traumatizing. And exactly what you said is that imbalance of power just continues. It's so the re-traumatisation of victims again and again by the family court system is something that really needs to be looked at. It puts women on the back foot. And again, going back to, you know, what I was saying about the funding with legal aid, and the fact that women tend to come off second best in any sort of separation financially. It's such a fact. And so often we're in the courtroom unrepresented. We don't even have the support of a lawyer or a barrister in that. I've been refused personally to have a Kenzie friend sit at the bar with me, and, you know, as a support person. And so under those circumstances, I've been told, I don't believe you. You're not a credible witness. Why are you so nervous? You must be lying. No, it's really traumatised. And you're doing just re-perpetrating the abuse on me by saying those things in this setting.
Exactly. Yeah, thank you. Well, I think, are there any winding up questions? No. Are there any final comments that you'd like to make in terms of the evidence that you presented, or other things that have come to mind when we've been asking questions?
As I've said in my statement, I think, you know, a royal commission into the family court is really warranted at this point, but it needs to be something that's overseen very externally, that can't be contaminated. I think that there's a general sense that there's a lot of sort of underhandedness that goes on within that system, and it would be really, really beneficial for women moving forward. It's too late for my child, and it's too late for many of the children who have been caught up in this thus far. They've got a life of really heavy mental health issues and trauma ahead of them, and it's really sad. But, you know, if we can do something to look into the way in which these systems are re-traumatising and re-perpetrating the abuse, that's, you know, something that really, really needs to be looked at and dealt with really appropriately.
Good. Thanks so much. We really appreciate your having come to give evidence, Lauren, and thank you very much for your submission that we'll incorporate into our report to the CEDAW Committee when we make our submission. Thank you.
Thank you for coming.
Good. Thank you.